My previous video on defamation law appears to have been well received, and some people wrote to me with follow-up questions. In this video, I thought I would tackle the questions that were about the truth defense, or what we know as the defense of justification. I also received a rather good question entirely from one legal academic from the University of South Australia about the nature of courts. I promised Dr. McIntyre that I would cover his question and answer in this video, but I'm hereby reneging on this promise in order to incorporate it into a different video. So let's get back to justification. The question goes something like this. Louise Milligan is a very experienced journalist, and she wrote a series of factual statements that were confirmed by the Attorney General, Christian Porter. So why doesn't the truth defense apply? So let's slow the argument right down so that we can see all of the moving pieces. First, the ABC published that there was an allegation. Second, the ABC published that it was about a senior cabinet minister. Third goes the argument, points 1 and 2 are facts. And then, in conclusion, because truth is an absolute defense, the Attorney General doesn't have a case. But this is confused. The truth defense, which we call justification, is much more complex than this. The reasoning that we see in the public debate is actually backwards, starting with the defense and then constructing the complaint. Let's go through this by starting with the intuition. You might have heard the expression that the truth is an absolute defense in defamation law. In one sense, this is true, but in another, far more commonly, it is confused. So let's talk about the true sense. There are a number of defenses in tort generally, and defamation specifically, that can be defeated, even if the elements of the defense are proven. It's easy to think of this like a tennis match. So here is Andre Agassi. He's the plaintiff. He's established all the elements to the cause of action in defamation, and whack! The ball goes to the defendant's side of the court. And oh hey, it's Venus Williams. She has a defense available to her in defamation law. Whack! The ball goes back to the plaintiff's side of the court. And oh no! The defense can be defeated if Andre Agassi can prove some additional elements. In defamation law, we are usually interested in something called malice. So whack! Agassi hits the ball and it's game, set and match for that defense. But it's an entirely different matter if it's an absolute defense. For an absolute defense, the defendants can make out the elements of the defense and there is nothing the plaintiff can do. There is no return shot. In this sense, truth is an absolute defense. There's no return fire from the plaintiff if the defendant can make out the elements of a truth defense. Let's take an easy fictional example. Let's imagine that Luke Skywalker here, instead of spending his retirement years on a planet managed by the fish people, decided to become the president of space. His opponent is Ahsoka Tano, and Ahsoka is in the race to win. She holds a press conference and says, "This jerk, Luke Skywalker, do you know who he is? The son of Darth Vader." And if that weren't enough to show what a shady character this Luke Skywalker is, he kissed his sister. And Luke's like, what the hell, I'll see you in court. And what he doesn't realise is that the Galactic Republic has adopted Australian defamation law. The truth defence is available to Ahsoka even though she was using the truth in bad faith. The truth defence cannot be defeated by Luke hitting the ball back with evidence that Ahsoka published these facts for sinister reasons. But let's be sharper here with the real question that you need to ask. The truth of what? And it's here that we see why the rhetoric of truth being an absolute defense is often confused and poorly understood. So here is Lex Luthor, and he really, really hates Superman. He knows 3 facts. First, Superman is from the planet Krypton. Second, the planet Krypton was destroyed in a massive explosion. And third, shortly before the planet exploded, Superman was seen flying fast at great speed away from the planet. These 3 things are facts which Lex can prove. So he sits back and enjoys a drink, basking in the glow of truth being an absolute defense. But this time, Superman gets a lawyer, She-Hulk, and She-Hulk explains that what defamation law is really interested in is imputations. What are the defamatory meanings? Not just the literal words, but the meanings that those words convey of a publication. And in this example, Lex Luthor has put 3 facts together to communicate a 4th assertion, that Superman is somehow responsible for the destruction of the planet Krypton. And this might cause Lex some worries. He has no truth defense for that, and so he'll have to look elsewhere. And this is the core problem with people saying that truth is an absolute defense. The truth of what? The truth of the imputations is an absolute defense, but the literal truth of the words on the page is not. And this gets us to the issue of Christian Porter. His statement of claim lists the imputations over which he is suing, and they are quite graphic, so I will not repeat them here. But he's not saying that the facts expressed in the article are necessarily wrong. He is saying that the meaning that those facts convey are wrong. And this is a really well-known concept in defamation law. Here is Lord Devlin's quote in Lewis and Daily Telegraph. "A man who wants to talk at large about smoke may have to pick his words very carefully if he wants to exclude the suggestion that there is also a fire. But it can be done." And this ends up being a question for the court. Did Louise Milligan navigate the right pathway that only conveyed the meaning that there was an allegation, or did her article and associated media posts convey more meanings to the reasonable reader? And you might have personal views about where the line should be drawn here. But it's important to remember why we put so much emphasis on imputations. As we saw with the Lex Luthor example, we don't want an environment in which media companies can distort facts to encourage the reasonable reader to take away incorrect meanings. So here are the Wagners. In 2015, Channel 9 made several allegations about them, including that they were responsible for the deaths of 12 people in the Grantham floods. Justice Applegarth said that the journalist involved was recklessly indifferent as to the truth or falsity of those imputations. Now imagine that it's you, and a media company has presented a series of facts in a way that unfairly and unreasonably characterizes you as responsible for an atrocity. Should the media company win the defamation claim by saying, look, all of our printed facts are correct, we are not responsible for how readers interpret the facts? But there's another side to this. This is Matt Collins QC. He makes the very sensible argument that there's something unusual going on with the way that defamation law takes meaning. You don't argue what the ordinary, reasonable person would interpret the material to mean. Instead, defamation cases are about how well the lawyer is able to craft the imputations into something that the ordinary, reasonable person could interpret the material to mean. The result, he says, is that imputations in any serious case are formulated by the small number of ingenious lawyers who have mastered the arcane art of defamation pleadings. He also says that Australia has a baffling obsession with imputations. There's a bigger point to this disagreement, and it's about trial procedure. So this is Dr. Chow Chuk Wing, who was defamed by the ABC and Fairfax newspapers. He was defamed so egregiously that, come the end of the trial, the ABC and Fairfax had no positive defence. They could not say that the imputations they conveyed were true because there was no evidence to suggest that they were, and none of the other defences appeared to apply. But here's the important bit. In Alice in Wonderland, the Red Queen presides over a trial in which she exclaims, "Sentence first, verdict afterwards." And this is not far off the problem with imputations in defamation law. Defence first, imputations afterwards. In the case of Dr. Chow, the ABC and Fairfax had to put up positive defences for the imputations alleged by Dr. Chow without a decision as to whether or not the imputations had actually been conveyed. This becomes the problem. Defendants have to say, "Look, Your Honour, we submit that the article does not mean what the plaintiff says it does. But in the alternative, we honestly mean what the plaintiff says that we mean." Matt Collins' argument is that we need to fix this. If plaintiffs get a lot of scope, and they do a lot of scope, for crafting their imputations, then very early in the proceedings, there needs to be a decision made about whether or not the imputations are really conveyed by the materials. So his argument is twofold. First, we need to change defamation law to focus on the actual meaning rather than the possible interpretation, and as you've seen earlier, you might disagree with this. But second, if you are going to keep the focus on imputations, then there should be a decision earlier in the trial process to determine whether the imputations have been conveyed by the material. You might agree with that, but remember that Australia has capped damages. There are a lot of aspects to defamation law that very sensible people argue should be handled earlier in the trial. Severity of harm, for example. The result is what we see in the United Kingdom, where this has resulted in a kind of mini-trial before the real trial. And although mini-trial sounds adorable, it racks up costs. And when you've capped the damages, it means, especially for difficult trials, that you could win your defamation case and end up with ruinous legal bills. But let's get back to the main discussion. From this video, I hope it's clear that imputations are complex and that there's a tension. On one hand, you don't want media companies distorting the facts so they encourage defamatory conclusions without outright stating them. On the other hand, you don't want the situation where imputations are simply legal dark magic that distorts the obvious meaning of the publication into something that's difficult or even impossible to prove. I also hope that it's clear that when we talk about the defense of justification, we're talking about the truth of the imputations and not the truth of the text. You don't start with the facts in the written material. You start with the imputations pleaded by the plaintiff. You need to show the truth of those imputations, not the truth of the text of the material. I hope I've shown that there's lots of room for intelligent, reasonable disagreement. You don't see a lot of the debate about defamation law in the media because Australian media companies are lobbying for changes to defamation law. If ever there were a conflict of interest in reportage, you would think it would be this, where the companies are arguing for weaker regulations. Finally, let's apply all of this to the Christian Porter case. He's not arguing that the text of the article is necessarily false. He's saying that the imputations that arises from the article is defamatory. The ABC has two overlapping options. First, the ABC can argue that the imputations asserted by the Attorney General are not conveyed by the materials. Second, the ABC can argue a positive defence to publishing the defamatory imputations, such as the truth of justification, honest opinion, qualified privileged, and so on and so on. What's not available to them is a defence that says, we got all our published facts correct and we are not responsible for how people interpret it. So that is it for for this one. I will see you next time.